David Clendon.
Thank you, Mr Speaker. And I'm pleased to take a call on behalf of the Greens to express our support for this legislation. We think it's a good bill that will achieve some good outcomes. We note that to a large extent, of course, it follows the recommendations of the Law Commission review in 2013 of the primary legislation, the 2006 Evidence Act. So the preamble to the review essentially says that the Evidence Act is pretty robust, quite fit for purpose. The Law Commission didn't find too much wrong with it. They did nevertheless manage to generate a fairly substantial document with a lot of detailed commentary in it, and that's a good thing. But out of that has emerged the provisions of this bill, and we see them as being quite positive and forward-looking. So the Minister in her introduction, as has been noted, made some comments about the importance of doing as much as we can to reduce the stress of people who are obliged to give evidence in a court. It's almost inherently going to be stressful, particularly for complainants. There is the risk of re-victimisation of people who are obliged to speak to and to describe events, often very traumatic events, which no doubt they would much prefer to put behind them and to speak no more about. Of course, the legal system does quite rightly require them to give that evidence, so anything we can do to reduce the likelihood of victimisation or re-victimisation, to reduce the stress and trauma involved in the legal process is to be desired, and we think this bill will make some contribution to that. In terms of some of the specifics, of course, the bill does seek to enable more previous consistent statements to be admissible and to extend a privilege that currently applies to settlement negotiation and mediation in civil proceedings to include plea discussions in criminal proceedings. And I must confess, sir, that as a non-lawyer and a person who to date has managed to avoid being embroiled in significant legal proceedings, I was unclear initially exactly what the background to those statements were, what the implications were. Fortunate to have an EA who does have legal training, who is able to guide me through some of that, and I'm sure the Select Committee will deal with those matters, but clearly they are matters which do seem to have positive outcomes or potential outcomes in terms of the matters that will come to the court. So the restriction on video recording evidence essentially put in some boundaries, ensuring the safety and security of those of any recordings that are made either by victims of violence, of sexual violence, or all matters, all evidence given by children is important. Clearly, people in that position of giving such evidence are vulnerable. It's a very difficult time for them. It would be unfortunate if video of their contribution of giving their evidence was made more generally available than was absolutely necessary for the court to do its work. So that's a good provision of the bill. Similarly, we wholeheartedly support the requirements for evidence of previous sexual history. Sadly, sir, in the past it was possible for complainants, particularly in matters of sexual violence, to be subject to some really quite aggressive, irrelevant and very intrusive questioning around their entire sexual history. That was often more to unsettle the complainant, to challenge their credibility, than it was to actually bring matters of relevance and value to the particular proceedings. And to the extent that any investigation or any questioning of a complainant's sexual history will only be in relation to the defendant, that it has to be agreed up front by the court that it will be heard. Matters of relevance, justification will be considered. It's kind of a no surprises approach, and it does enable people who will nevertheless be required to reveal quite intimate details of their personal lives will at least have the security of foreknowledge of that and be able to prepare for it to the extent that one can do such things. Similarly, we're pleased that the change to a presumption that children or those under the age of 18 giving evidence in court will use alternative methods, will not simply stand in the dock in a way that an adult might. We have not always been fans of the change in presumption around matters, and I think back to some of the legislation passed last year or the year before, where presumption of innocence was overturned for some offences in favour of a presumption of guilt. That we were not terribly thrilled about, but in this instance, the switch of presumption we think is positive. It may well be that some 16, 17-year-olds are perfectly confident to stand in court, give their evidence as if they were adults, and certainly the presumption change doesn't preclude that, but it does make it clear that any arguments will need to be made for other than alternative mechanisms to be used, and we think that's a very positive thing. We do have the technology, the capacity now to protect young people when they're giving evidence, and it's important that we do that. I'm interested to hear some of the comments about the nature of the support person who might be considered appropriate, and I'm sure that the Select Committee will come to that, to those matters as they do others. I do look forward to the Select Committee investigation of this bill, to hearing evidence and submitters to it. It is a good and well-functioning Select Committee. We do, I think, get, for the most part, to the bottom of matters, and I do think that the evidence the submitters we hear, let me say, shouldn't get too presumptive, but I assume that for the large part they will be supportive of this, but nevertheless, invariably initial draft can be improved on, and I look forward to be part of that work. Thank you, Mr. Speaker.